Hey, it's Bernard Nomberg with the Nomberg Law Firm, and a situation that arises quite a bit in our work comp cases is the following. Injured worker has reached a point in medical care recovery where the authorized treating doctor has determined that it's okay for the injured worker to return to work in a modified position or modified duty with limitations. So let's say that they're sent back to work in a light duty position, and the employer says, well, we have a job that will accommodate light duty. However, the injured worker says, I'm in too much pain, I can't handle any type of work right now. What happens? Does the employer insist that the employee come back to work? Well, sure they do. Most folks in Alabama are part of what is called an at-will employment situation, which doesn't leave a lot of rights for injured workers. There are certain situations where they do have more rights. But does the employee now have the obligation to report to work? Well, yes, they do. But then what happens when the employee says, what if I take my sick, accident, or vacation days? Can I do that? Well, it really depends on the policies of the employer and what their standards are. It may be that the employee can take a certain period of time off. It really is a case-by-case situation. However, if that's abused or if they appear to try to be calling out or laying off too much, the employment may be jeopardized. Every situation is a little bit different. It's case-by-case situation. It really is determined on several things, but we deal with this quite a bit. Please consider giving us a call if this is your situation. We'll be glad to walk you through it and talk you through it. We may be reached at 205-930-6900. NombergLaw.com is our website. We also have a YouTube channel, lots of videos there, Facebook and Twitter.